Hi, I am Abhilasha Nautiyal and I practice intellectual property law before the Delhi High Court. Today, we will talk about the module on well-known trademarks. In this module, we will cover what are well-known trademarks, are well-known trademarks recognized in India. We will also understand the reason why some trademarks are recognized as well-known trademarks and the criteria for recognition of marks as well-known. We will conclude with understanding how such well-known trademarks are enforced and recognized. We will now start with understanding the meaning of well-known trademarks. As you know, brands are important and they are omnipresent today. Brands have value to consumers because we prefer different brands differently. Brands also have value to the supplier of the brand. As you know by now, trademark law was chiefly designed to protect the interest of the consumer. Trademark law did so by protecting the consumer from being confused of deceptively similar or identical trademarks that did not come from the proprietor of the mark. This is known as the sole identification function of a trademark. In addition to this, a brand also is of value for the proprietor of the trademark. But does trademark law protect the interest of the proprietor, or is it always the interest of the consumer? Well-known trademarks and the doctrine of dilution come to the aid of the proprietor. Now, both of these doctrines are of recent origin compared to other settled principles of trademark law. Both can be seen as somewhat of a deviation from the traditional principles of trademark law that seek to protect the interest of the consumer. Now, before we go to the statutory definition of a well-known trademark under the Trademarks Act 1999, let me give you a few examples of what marks have been recognized as well-known trademarks. Benz has been recognized as a well-known trademark. So has the trademark Tata. Now, you would have a brief idea of what kind of trademarks are generally identified as well-known trademarks. Now, section 2 clause 1 clause 2G of the Trademarks Act defines what a well-known trademark is. Let us study this provision to understand the meaning of a well-known trademark in India. This provision provides a mark which has become so to the substantial segment of the public which uses such goods or services or receives such services that the use of such mark in relation to other goods or services would be likely to be taken as indicating a connection in the course of trade or rendering of those services between those goods or services and a person using the mark in relation to the first mentioned goods or services. Now, let us understand this definition by way of an example. A mark, say Mark Tata of Tata Sons Limited, which the substantial segment of the public uses for particular goods or services, is used by another person for other goods or services, say for example by a third party for Tata Diamonds. Now, is this likely to indicate a connection between Tata Sons and Tata Diamonds? In this case, the Delhi High Court answered in the affirmative and said that Tata is a well-known trademark and restrained the use of Tata by unrelated parties for unrelated goods and services. Now, from the definition of a well-known trademark itself, you can see that well-known trademarks are enforced against parties using those marks for unrelated goods and services. For instance, if your mark is registered for say stationery and subsequently your mark is recognized as a well-known trademark, you can actually stop someone from running a hotel under your trademark. Now, this does give far more protection to marks than is traditionally given under trademark law. Now, is this unfair? Should such wide protection be given to trademarks at all? Let us examine why well-known trademarks are recognized to answer this query. Now, the reason why trademarks are recognized as well-known trademarks, there are at least three primary such reasons. Firstly, it is to prevent unfair use of a mark's reputation. Secondly, to prevent harm to the reputation of a trademark. And lastly, obviously, to prevent consumer confusion. Now, we will go through each of these reasons to actually understand why such great protection is accorded to some trademarks. As you know, some marks do enjoy greater reputation than others. I will explain this point by way of an example. Now, this example is actually a case that was decided in 1994. What happened was, the Benz TriStar logo, which is recognized worldwide, was used by a party in India for unrelated goods. Now, this party in India was obviously not making cars or selling components that were used with cars, or even giving services that were vaguely related to cars. This party was using the Benz TriStar on undergarments. Now, under traditional trademark law principles, such use would be permitted. If Benz did not have a registration for the TriStar logo in the relevant class, which is for undergarments, then Benz could not have restrained this third party from using its Benz TriStar logo. But it was held that such use would amount to infringement of the well-known trademark, which was the TriStar logo, because that TriStar logo had great reputation, and this party, the defendant, was actually taking unfair advantage of the great reputation that the TriStar logo enjoyed. Now, you can also view this from another angle. When a proprietor invests a lot of effort, time and money in building the reputation of a trademark, is it always fair to let someone else take benefit of that reputation? This is one of the reasons why some marks are recognized as well-known trademarks and are enforced against parties that use them for unrelated goods and services. We will now discuss another reason why some trademarks are given the special status of a well-known trademark, that is to prevent harm to the reputation of a trademark. Let us understand this point by way of an example. Consider the trademark Tata. Now, Tata is a well-known trademark in India and consumers associate it with a group of companies. What happens if a party starts using Tata in a derogatory manner? To answer this further, let us examine the doctrine of dilution. A doctrine of dilution is a way of enforcing well-known trademarks. There are two aspects to the doctrine of dilution. First is dilution by blurring, and second is dilution by tarnishment. We will first understand the meaning of dilution by blurring. Dilution by blurring is basically what the name suggests. It is dilution of the reputation of a trademark when several other parties start using it, causing the reputation of the trademark to blur. The second aspect of the doctrine of dilution is dilution by tarnishment. Now, this is a case where a famous trademark may be used by another party in a derogatory manner. Now, in this case, the derogatory use of a famous trademark may lead to harm to the reputation of the famous trademark. Hence, a famous trademark may be protected by enforcing the doctrine of tarnishment. These are another reason why some trademarks are recognized as well-known trademarks.